Morning, everyone. My name is Stephanie Collins. I'm from the Bristal at Holtsville. We're actually located right at exit 63 on the North Service Road. So you've probably seen it passing on the LIE. We've been here 4 years, so we're a relatively new community. We do offer assisted living, and we also offer a secured memory care unit if you have a loved one who needs any of that. I just wanted to speak briefly that we have been COVID free throughout the whole time. We've really kept our residents safe. We got ahead of the curve. We did some quarantine, but still they enjoyed meals in their apartment and a lot of socialization in the hallways with exercise programs and entertainment and still keeping them safe. It's much different now. We're back to dining in our dining room, safely doing activities throughout the community. We allow families to visit. We've been doing that outside in tents, but now we've moved it inside. So the families still get to see their loved one, which is a really great thing. All the employees here are tested weekly. If the residents would like to be tested, they are as well. So we've really kept everyone safe. We offer an enhanced license, and that just means that someone can come here very active and independent and then age in place with all the services, that all the way up to, helping them if they can no longer walk, pushing them in wheelchairs, things of that nature. So it's good to keep that in mind because not all communities offer that. But also I'm available if anyone has any questions. I can also do a virtual tour if you just like to see what the community looks like. But, going forward, please always feel free to reach out, and give me a call. My name is Stephanie, and enjoy the seminar. And I'm going to pass it over to Britt at this time.
Great. Thank you so much. That's amazing. You guys have been COVID-free the whole time. Congratulations.
Thank you.
Okay, I'm going to share my screen so that we have a little bit of a PowerPoint here just to follow along. So let's make sure I do this right. Okay, there we go. So I am Britt Berner. I am one of the attorneys at Berner Law Group. We are an elder law trust and estates firm that was started in Setauket by my mom, Nancy Berner, 25 years ago. And we now have offices in East Setauket, West Hampton Beach, and in Manhattan. All 3 offices are fully operational, although in the city we are still mostly working remote, although we're in a little bit, but not too much. Luckily, we've been able to really keep up with our clients and keep up with everything remotely, which has been really great. And then we're out in West Hampton and Setauket. And, I did a webinar the other day about what is elder law. And one of the things that's really important to realize about elder law is it's really just figuring out how you're going to use your assets to care for yourself and also pass them on to your loved ones if that's something that's important to you. And so at the heart of that are things like tax planning and estate planning. And that's what gets us to something like the Secure Act. So I'm going to talk today about the Secure Act. I'm going to explain what it is, where it came from, what the rules were before we had the Secure Act, and what you might want to look at or what you might want to check up on in your own life, in your own situation, your own documents. So the Secure Act, this is what it stands for, setting every community up for retirement enhancement, and that's how they got secure. And this was passed in December of 2019. In December of 20, and this is a federal act. This is the federal government that passed this. And what it is meant to do is to change the landscape of retirement planning. So those 401ks, IRAs, 403bs, 457 plans, those tax sheltered plans where you saved money while you were working, while you were earning, and that those were tax deferred assets. And when you hit a certain age, you start taking distributions from that. And we call those RMDs, required minimum distributions. And you take those for the remainder of your lifetime, and then you pass those assets, whatever's left, on. But that is all money that has not yet been taxed. And so that's what we're talking about here. That's really at its base what we're talking about. I always tell people that the Secure Act kind of snuck its way in. It was signed right, maybe, I think it was December 20th, it might have been, of 2019. So it was right before Christmas, right around the holidays, right before the new year. People weren't really paying that much attention. And it was really something that, as estate planning attorneys, we had heard might come through, these types of changes. But then it kind of died out. And then all of a sudden it was a new law that was passed. And then, starting February, March, all of the COVID conversations started, I would say heating up, but it was obviously a lot more than that. And the Secure Act kind of got left behind. And so I think it's really important to educate yourself on the Secure Act, just so you know it may not affect what you should be doing in your own life, but it may. And so it's important to understand the basic things that were changed to determine if there's any changes you need to make to your own planning. So before Secure, obviously Secure Act covered a lot of things. I'm just going to do the things that are kind of the most relevant to most people today. So RMD, we said the required minimum distribution. So it always was that you had to, at 70 and a half, take a required minimum distribution based upon your life expectancy from that account. So if you had a $500,000 IRA or 401k, you would, at 70 and a half, there would be a calculation based on a life expectancy table that the IRS creates that says what percentage of that account you need to take based on how long the IRS says you have left to live. You take that percentage, and that's your RMD. Some people chose to take them in a lump sum, maybe at the beginning of the year or the end of the year. Some people divide it up by 12 and take it as a monthly income, like Social Security payment, to keep themselves on a budget. You can do whatever you want, but you have to take that distribution every year. So before Secure, 70 and a half was the age that you had to do that. Before Secure, we also had the inherited IRA, the stretch. You take a stretch is the terminology we would use. What did that mean? That means that if I left my retirement account to someone, anyone other than my spouse, because spouses get a rollover and get the same rules that I would get as the initial owner of the plan. But say I left it to my children or my sister or whomever I left it to, they could then, if they were named as a beneficiary with the account on the forms with that institution, it would roll over into an inherited IRA, and they would have to immediately start taking distributions. And the year after I passed away, they would take distributions, and it would be over their life expectancy. Now, presumably, if a 90-year-old person passes away, their children are 20 to 30 years younger than them usually. And so their life expectancy is much longer. So the payout is much smaller. So the child or the grandchild or whoever it is continues the benefit of having that money be tax deferred and only being taxed on the distribution that they have to take. Now, if my required minimum distribution based on my age was small and I wanted more, I could always take more. But that was additional money that I was getting that I wasn't income taxed to me at my rate, because that's additional income that I'm receiving in that year. But I had that right as the beneficiary, and it would stretch over my lifetime, and then it would be left to whomever I named as beneficiary on my inherited IRA. That was before Secure. Another thing that was kind of the basis of Secure was whether or not somebody was the basis of the retirement accounts was whether or not somebody was a designated beneficiary. And I should have put that in quotes, because that is a term that very specifically refers to a person that is listed on a beneficiary designation form with the retirement account. So when people have an IRA, we don't usually recommend that they put as the beneficiary the estate of Britt Berner, my estate, whatever it is. We recommend that they put an individual person, because then that individual person can roll it over into the inherited IRA and take the stretch over their lifetime. If I named something like my estate and I had 3 children and the 3 of them were then each getting a third of that based on that, they're not a designated beneficiary. And so they had to take a payout over 5 years. And so obviously, if I have a $500,000 account and somebody can't take the stretch, well, now they've got to take a lot of taxable income in a short amount of time. It could bump them up into a higher tax bracket, and certainly is more, and they're not letting it grow and invest tax deferred. I didn't mean to put 5 versus 10-year rule here. The 10-year rule we're going to talk about when we talk about secure. So these were the rules before, right? You had to take your RMD at 70.5. You could take a rollover into an inherited IRA if you were a non-spouse beneficiary, and then that would let you stretch it over your lifetime rather than have the 5-year payout. So the basics. These are the basics of secure. So there are new rules for business owners setting up employee plans. The idea is it's going to make it easier for smaller businesses to open up employee plans. That's a good thing. They are allowing you to continue to contribute to a traditional IRA. Now here's a big change. You now don't have to take your required minimum distributions until you're 72. So take someone who turned 72 this year. Then there was the CARES Act because of COVID that says you don't have to take required minimum distributions this year. That person's actually delaying that distribution if they want until they're 73 years old. They can take it next year. So this is a big change. That year and a half might not seem like a lot, but again, that's time that asset can continue to grow tax deferred. 529 plans, there was a change that's for college savings. There's a change to how you could, they allow you to now repay qualified student loans up to $10,000 a year. There's now a $5,000 penalty-free withdrawal when you're having a child or adopting a child. That's allowing somebody who's younger, who has most of their savings in one of these employee, structured plans, their 401k, their retirement plans can actually take from that when they're having a child to help them out. That's great. And then there's this 10-year beneficiary payout. And that should actually have, big, bold letters. And that's the big change here. And that's where I think most people's beneficiaries are affected and they don't realize it. So what that is saying is that you now, rather than getting that stretch, the non-spouse beneficiary must take a full payout of that retirement account in 10 years. That's a very big difference, because if I'm a 50-year-old beneficiary, I might have had a 40-something year stretch on that IRA. And so I'm taking very small distributions for a very long time, and that's continuing to grow tax deferred. Now, if I'm 50, I've got to remove that entire amount in my example before, all $500,000 within 10 years, and that's all taxable income to me. So that's a big difference for some beneficiaries, especially beneficiaries who are inheriting large sums in retirement accounts. Whereas some beneficiaries are getting life insurance payouts, or they're inheriting real estate, and they're not worrying about the fact that this is a totally untaxed asset that they're getting. So this 10-year payout is going to have to happen starting the year the person died. They have to take it over 10 years. Now you could take it all in year 1, you could take it all in year 10, any mixture of that. It just needs to be fully withdrawn by year 10. Now, obviously, for a larger account, it's probably going to be beneficial to spread it out over the 10 years so that you don't have a ton of taxable income in a given year. But that's going to change perhaps how people decide to do their planning. Now, there are 5 exempt categories of beneficiaries for who can not get the 10-year, and who is these people, these 5 exempt categories can get the stretch, that inherited stretch over their lifetime that I talked about before. A spouse, so that's the same. A minor child, but that is different for a minor child. They can take a minor child can take it over their lifetime. A disabled, and that's a minor child of the person who passed away, not their grandchild. That's going to be a different rule. a disabled individual, a chronically ill individual, or an individual not more than 10 years younger. So think about, if I'm leaving my retirement account to my sibling who's 5 years younger than I am, they can take a stretch over their lifetime. The difference between a minor child and any other minor that you might be leaving to, a grandchild, a godchild, any close friend's child, is that any other minor other than your direct child can basically take it over their life expectancy until they turn 18. It holds off on that 10-year, and then the 10-year starts when they turn 18. They'd have 10 years to take out the balance of the account. So that's the difference between if it's my child when I pass away as a minor or any other minor that I might be leaving assets to. So how might this make you want to change your planning, right? What is this going to mean possibly for you? So it should definitely mean that if you have retirement accounts, you should be reviewing your existing estate planning. I think that's across the board. If you are a person with retirement accounts, it's a good time to review what you have and make sure it's still okay and see if there's any tweaks that you may want to be made. I've had many clients who've come in since December and we've talked about it, and in the end, they understand the change, but there's nothing that they're deciding to do. But it's important to get that counseling and get that advice on this change. We always say that it's important to review your estate planning every 5 years or when there's a major change. Now, that could be a major life event for yourself, retirement, birth, death, selling your home, relocating, all of these things, but it's also a major change in the law. So this is a good time to go in and review your estate planning. You may have had an accumulation trust or a conduit trust, and you may want the other. What is that? There are certain types of trusts that are often named as beneficiary of retirement plans, and if written properly, they can get, in the past, they could get that stretch. Now you want to make sure that if you do have any trusts that your retirement plans are paying out to at your death, that those are still the best thing for your beneficiary. Another option for some people decide, I'm going to take more than my required minimum distribution while I'm alive, and I'm going to pay the taxes on it because that's going to leave less of an asset that needs to be taxed to my family members, because maybe my children are in a higher tax bracket than I am, or for some other reason, it's better if I take on a little more tax burden to alleviate the tax burden a little bit on them. You can also take more required minimum distributions while you're living and perhaps use it to pay the premium on a life insurance policy where the death benefit is going to that same beneficiary, but it's not going to be taxed in the same way. Or maybe you can qualify for long-term care insurance and you want to take a little more from your required minimum distribution to pay the premiums on long-term care insurance. Again, none of these things are legal advice for anyone on this call or are 100% what anyone should do, but they're the kinds of things that you should be talking to your attorney, your tax advisor, your financial advisor, your insurance advisor, whoever it is that you go to for advice. These are the things that you should be discussing with them. You may want to change your beneficiaries. I'll give you an example. I had a client who in her will wanted to leave a certain amount of money to a charity. And charities, when they receive retirement accounts, don't pay income tax on them. It is a benefit to leave that to them. So what I said to her was, maybe rather than giving the retirement accounts to your son, in this case it was her son who was in a much higher tax bracket than she was, maybe you should give more of the other assets that are not tax deferred assets to your son, and you should have the charitable bequest come out of your retirement account at your death. You name, 20% of your retirement account perhaps to go to the charity that you want to benefit. You may want to change to your siblings. Again, I had another client who had no children, but she had several siblings that she wanted to make sure got something at her death. And she had been leaving them bequests in her will. And I said, well, maybe we should be shifting that. Maybe they should be receiving part of your retirement plan because they are less than 10 years younger than you. And so they'll be able to take the stretch over their life expectancy. Maybe that's a better plan. and we can look at the effect on those siblings and if that makes sense. So you may want to shift around what assets goes to which beneficiary. Or if you have a disabled or chronically ill beneficiary, there are now trusts, different ways that we're creating the trust. So if you have an existing supplemental needs trust for one of your children or grandchildren or someone else that you're looking to benefit, you may want to amend that trust or draft a new trust and have the retirement accounts pay in there. It used to be that we wanted to be careful about paying retirement accounts over to a beneficiary who was disabled because of tax implications, but the tax implications have shifted. And so you want to review those trusts to make sure that that all still makes sense. So that is our very brief high point overview of what the Secure Act did and how it may change the way you are planning for your future and for the future of your loved ones and beneficiaries. So thank you to the Bristal for having us. This is my contact information. I'm gonna take it off. I guess I'll leave it up there actually, and we can take any questions. Liz, you can tell me if, I don't know if we have any questions. Doesn't look like we do yet.
I don't have any questions now, but just as a reminder, if anyone does have a question, there's a Q&A section on the bottom of your screen or on your panel, depending on what device you're on. Excuse me. You can just type in any questions that you may have, and we'd be happy to answer those.
You know, I'll just say, as you know, as people are possibly not formulating their questions, you know, I think the big takeaway here is the review of your documents. And I can't say that enough because I think there have been so many changes in this past year in how we think about estate planning based on these changes in the law, based on COVID, based on things we've been seeing. It wasn't a topic of discussion today, but there were changes to the Medicaid laws, community Medicaid, home care Medicaid that may affect some people. And so it's a really good time to refresh your memory on what planning you may have done and to see if there are changes that need to take place, because the laws change and hopefully your documents have been drafted in a way that it allows for flexibility and for changes based on these changes in the law. But I do have a lot of clients who've come in and they've reviewed, and in the end, there's just not much for us to do. But these kinds of seminars are great to understand the talking points and the high points, but really getting individualized advice on your situation is going to be really helpful for you, I think.
Britt, we did have one question come up. If we inherited an IRA this year during COVID, isn't there a delay in when we have to start taking our distributions?
Yes, so if you inherited an IRA this year, then you're looking at the Secure Act is in effect. So there is, you know, assuming you don't fall into one of these exempt beneficiary situations, you will have to take a 10-year payout. But due to the CARES Act, there is a delay in taking distributions. So the CARES Act was, I don't remember the full acronym, but that was the COVID Act that was signed back, you know, when we started this, the stimulus that allowed for people to not take their required minimum distributions this year. You know, so that does change things, but you should still be figuring out, it's a good pause to be able to say, okay, we inherited this year, but now we can come up with a plan of the best way to take those distributions and what to do with them so that next year when you have to start taking them, you have a plan in place.
Thank you. The next question, what happens if the beneficiaries fail to take out all or part of the funds? Does the federal government take all of the funds away?
You don't take it away, but, you know, like anything else, you know, taxes and penalties. And if you don't, you know, if you leave it all, say it is a $500,000 IRA and you don't do anything, you get to year 10 and the government says, okay, now you've got to pay out that account, you're getting a $500,000 check of $500,000 worth of taxable income. So if you make $100,000 a year, you're now paying taxes as if you make $600,000 a year. And so you want to deal with it and come up with a strategy early so that you don't get stuck with the big tax bill at the end. So I guess in some ways the government would take it, but not that it would just go to the government, but there would be heavy taxes on that. And it would also heavily tax all your other income because it's now putting you in that higher bracket.
Thank you.
Thank you so much for joining us, and hopefully we'll see you next time. Enjoy this beautiful day.